Paula?
Yes.
This meeting is being recorded.
Relating to intellectual property. This year, the World Intellectual Property Day's theme focuses on IP and youth innovating for a better future. This year, we invited more students to attend this presentation to make them aware of intellectual property. World IP was started in 2000. The WIPO's member states designated April 26th, the day on which the WIPO, the World International Property Organization Convention, came into focus in 1970 as World IP Day with the aim of increasing general understanding of IP. So that's why we have World IP Day. Our goal here at TCA is to help the innovators and entrepreneurs of New Mexico learn about intellectual property and how to protect one's ideas. We offer no-cost confidential counseling regarding intellectual property. My name is Estefanita Rawlings, and I am the TCA Coordinator / Center Director at the Technology Commercialization Accelerator. We are one of the 19 small business development centers here in New Mexico. This year, our World IP Celebration lineup consists of presenters from the Texas Regional Outreach Team of the USPTO office and the New Mexico FAST program at Arrowhead Center at New Mexico State. Our presenters will be providing an overview of intellectual property, which consists of patents, trademarks, copyrights, and trade secrets. And we will also be learning about seed funding that is available through a competitive process from 13 federal agencies. We also have from our host school, New Mexico Tech, Dr. Myrriah Tomar, the Executive Director of the Office of Innovation, to welcome us. The TCA works closely with other agencies throughout New Mexico. We work with other SBDC agencies to assist clients with business startups and IP strategy. We also provide our clients information on other agencies that will help our clients move forward with their ideas. We try and educate our clients on what intellectual property is, why we want to protect it, and steps needed to be completed to protect one's intellectual property. We try to educate our clients on intellectual property. Schedule a meeting with the TCA to learn about moving your idea forward. Some background about the TCA office. We opened up the office 2 years ago during a pandemic. We have been operating as a virtual office. We meet with our clients via Zoom and telephone calls. We provide free webinars like this one regarding intellectual property through the New Mexico Small Business Development webinar and training schedule. The New Mexico Small Business has a YouTube channel where our webinars can be viewed at your convenience. We have a website at New Mexico and at nmt.edu/TCA/. And we are here to help you move forward with your idea. I want to thank Christopher for introducing us. I want to introduce Dr. Myrriah Tomar from New Mexico Tech. So go ahead and take it away, Myrriah.
Thank you, Steffi. It's a pleasure to be here today. You know, New Mexico Tech is really excited about collaborating with the SBDC and helping to oversee the TCA. And one thing I really wanted to do before we get back to Steffi and introduce our panelists is to talk a little bit about the Office of Innovation Commercialization here at New Mexico Tech. This is an office that was created in 2017 by our current president, President Stephen Wells, and it was created to promote an entrepreneurial culture here on the Tech campus. We really focus on helping faculty protect their IP, commercialize their technology, and you know, we really see their IP as an asset, not only to them as inventors, but to the university. So I think, you know, in celebration of today, which is World IP Day, really understanding, you know, whether your ideas, process, method, or device is something that is patentable is valuable, I think, for you as a potential inventor or company. And then also understanding kind of what the commercial potential of the IP is. So with that, I just wanted to say hello, and I'll hand it back over to Steffi. So welcome, everyone.
I'm coming. I'm starting my video. Oh, well, thank you, Dr. Tomar. Next, we will have the Texas Regional Outreach, USPTO, Reynaldo Vasquez. Okay, Reynaldo, you're on.
There we go, double muted today. Good morning, everybody, or afternoon if you're in the central time zone like me. Happy to be here. My name is Reynaldo Vasquez. I come from the USPTO. I've been here for about a year now as a Texas Regional Outreach Officer, help manage the outreach component. The regional office covers 8 states, you know, Texas, New Mexico, Oklahoma, Louisiana, Arkansas, Mississippi, Tennessee, and Alabama. So we definitely cover all the southern state on the outreach component, doing training programming such as this. I come from the world of the SBA, Small Business Administration. So I used to do economic development for about 11 and a half years. Before that, I was with ICE, and before that, I was with the U.S. Army, and currently still with the U.S. Army National Guard. So I still stay busy, and but now I'm really focusing in the IP section of economic development. And this is one of the reasons why I wanted to come over here at USPTO and really help spread out the information on intellectual property. And it's something that typically doesn't get seen, especially by underserved markets, because most of the economic development usually happens in the bigger MSAs. So it's definitely something that I've kind of found to enjoy and really help individuals in areas that are typically not served. Saying that, today we'll be going over IP basics presentation, just to give you an overview of what the intellectual property is, 4 buckets and 4 different types of IP, and resources that USPTO has and what USPTO is. Saying that, I do have my colleague Dimple Sopariwala here with me, and she'll be helping co-present this presentation. Dimple?
Good
There we
morning,
go.
everyone. Thank you, Ray. Good morning, everyone, or good afternoon, because our central time zone as well as Eastern time zone is available in this conference. Before I start my introduction, first of all, I would like to say thank you to Dr. Tomar and Ms. Rawlings for inviting us and giving us the opportunity to present the IP basics during this event. So big thank you to them. My name is Dimple Sopariwala. I'm with the USPTO more than 15 years. I joined the USPTO as a patent examiner. I served as a patent examiner for 8.5 years. After receiving the primary examiner's titles, I served as an examiner for 3 more years. And then after 8.5 years, I feel like I want to explore some other part of the USPTO. As you know, that the USPTO is one of the biggest agencies worldwide because it has more than 8,000 examiners that working in one agency. So after 8.5 years, exploring another side of the USPTO. Currently, I'm working with the classification, quality, and international coordination outreach activities. In this one, like we work, maintain the quality of the classification that can be used to search for the patent applications, and also we provide the trainings and we do lots of implementations with an international patent office. Right now, I'm on a Texas regional office as a being loaner on a detail assignment, and this is my 2nd month with the Texas regional office. So I'm working with Ray and his teams as a Texas regional outreach coordinator. And that's all. And during our presentations, if you have any questions for us, you can feel free to reach out to us during the presentation, or you can wait until end of the presentation. So thank you once again, and I'm giving back to Ray to you.
Thank you. Can you share the presentation, Dimple? I'll
Yes.
start it up. There we go. You can just take it to full view.
Yeah, that's what I'm trying to do here. So just bear with me. Let me know
No,
if you are able to view it.
yes, we're good now.
Okay, perfect.
So you go on to the next slide. So we talked about USPTO, what U.S. Patent and Trademark Office. We are part of the Department of Commerce, so we help manage the intellectual property, which is on patents and trademarks for the United States. So just a quick overview of USPTO. Most of our employees are actually patent examiners. You can see about 13,000 employees that we had for fiscal year 21. 8,000 of them approximately are patent examiners. And something unique about USPTO, the patent examiners have technical backgrounds. So a lot of them will be engineers by trade. So you will see some scientists, chemists, but very diverse background in technical expertise. And that comes really because they're examining patents that are new and innovative. So USPTO wants to see individuals with experience to be able to handle these type of applications. So that's something very unique to the federal government, having technical expertise, and most of the USPTO would come from patent examiner world. We do have trademark attorneys as well to help examine all the trademark applications. There's a vast difference there in employees, as you can see. Trademark attorneys, we have about 662. We do have administrative patent judges and administrative trademark judges as well. And you can see the numbers, 244 for patent judges and 27 for administrative judges. And a lot of it is just because of the expertise in each industry. It varies tremendously. So we do, just to give you an overview of patents filed last year, last fiscal year, we had 650,703 applications filed, and we had roughly about 374,000 patents issued. They're not the same applications that get filed through, that get issued the same year, but it just what was accomplished that last fiscal year. Usually it does take a while for USPTO to examine the patents. Some of them can take a couple of years on average. So just to give you an idea of, how USPTO operates and the capacity. Something interesting, USPTO is also a fee-based agency. So we pretty much generate or operate off the fees that we're able to generate from the applications. So we're not taxpayer funded. So every time you're paying for a patent trademark application, that helps the funding of USPTO. And throughout the years, we've been seeing an increase of patents and files and filings, patent filings and trademark registrations. So that's allowed us to increase. And that's just a good indicator of the economy and how strong the US economy continues to be. And in the right-hand side, you see the trademark applications and with the certifications of registration filed. So like I said, we continue to develop as a nation, and especially with our intellectual property portfolio. And down there, you see our headquarters in Virginia. And I'll talk a little bit about the regional offices in the next slide. Next slide, please. In here, you do see the expansion of the regional offices from the headquarters in Alexandria. You see the territories that each regional office covers. And this happened largely in part because the Americans Invents Act in 2009. So that helped us expand more local presence throughout the nation. So we are in Texas regional office, which covers the 8 states that I mentioned earlier. We do have the Silicon Valley office in the west, Rocky Mountain office in the middle, and then Midwest regional office. And then we do have an Eastern Regional Office that houses out of the USPTO headquarters. So next slide, please. A little bit about the Texas Regional Office. We should be opening up due to COVID back in January or June 1st, and we'll be doing by appointments uh, solicitations, in case you wanted to visit us. We do have patent examiners, we do have judges such as PTAB judges and management staff such as myself in the office in downtown Dallas. And we do offer services like public search facility that we have in our office, examining rooms in case you wanted to talk to a patent examiner in a specific case, hearing rooms and public meeting space. As soon as June 1st hits, we should be able to open up or set up appointments by solicitation. That's something we look forward to. COVID has shut us down for the last 2 years approximately. So we definitely look forward to opening up to the public. And we're trying to see also the demand. A lot of the component that we're doing now is virtually, and we're able to reach more of our area. And we'll still have that option, but we're also going to start implementing the in-person side of it as well. So next slide, please. So the next part of the presentation, Dimple will be taking over, and she'll be talking about the content of the USPTO and the actual intellectual property side of it. Dimple?
Thank you, Ray. Is it okay if I don't turn on my video because my video and audio doesn't go well? Because as soon as I try to turn on the video and audio together, I'm not able to hear anything and it's not cooperating very well. So sorry about that. But in the middle of the presentation, I will try to pop up my videos, promise. So I would like to welcome everyone for this presentation. So thank you for giving me opportunity to present the introduction to intellectual property. So when we says intellectual properties, so what is the intellectual properties? So basically, intellectual properties refers to the creations of minds such as inventions, literacy, artistic works, designs, symbols, name, and image used in a commerce. So here are the basically give you overview of the intellectual properties. So you have to keep in mind the intellectual property is a category of the property that includes the intangible creations of the human intellect. The main purpose of the intellectual property law is to encourage the goods. To achieve this, the law gives the people and business property rights to the informations and intellectual goods they create, usually for a limited period of time. This gives the economic incentives for their creations, and because it allows the people to benefit from the informations and intellectual goods that they create and allow them to protect their ideas and prevent the copying. So as we mentioned that intellectual property is protected in a law by, for example, patent, then trademark, copyright, and trade secrets, which enables the people to earn recognitions or financial benefit from what they invent or create. By striking the by striking the right By striking the right balance between the interest of the innovators and the wide public interest, the IP systems aim to foster an environment in which creativity and innovation can flourish. Intellectual, for examples, as we mentioned, patent, trademark, copyrights, and trade secrets are the valuable assets of the company, and understanding how they work, how they are created is critical to knowing how to protect them. So I want to like to share one of the example because mobile device is like a very well-known device. Everyone has it. Everyone cannot get rid of the mobile device from them. So when we have a mobile device in our hand, do you ever think of it that how many intellectual properties associate with that one device? So when you look at it, the mobile device, you can see here we have example of the Samsung Galaxy Note. So Samsung Galaxy Note, those are the word, but those are the trademarks. Then when you explore more that device, Samsung Galaxy Notes, you can see what are the camera features, what is the battery life, what is the battery material, what is the screen material, what is the antenna, what is the data processing methods, what is the semiconductor circuits that associate in this mobile device. All these informations, it's a novel, non-obvious, and that's why it has been patented, and that's why those information you can find in a patent. That is also, and that patent is called as a utility patent. But when you look at the mobile device, the external appearance we call as an ornamental appearance, those are associated with the design patterns. So home button space, curved bezels, curved screens, those are the design features, and those are the associated with the design pattern. And the fourth one, the copyright, the software code, instruction manual, ringtone, all those are the prevented by the copyrights. And the trade secrets. Trade secret is like a company secret that nobody knows except the company. So as you can see from one device, you can see how many intellectual properties are associated with. Isn't that fun? So whenever you see any new device and any new things in front of you, you start to think that how many intellectual properties associate with this device or this, even if you are sitting in front of the computer because you are enjoying this trainings through the virtual, so you are in front of the computer. So that strike to you as well, that how many intellectual properties associate with this computer device. So that's the basically main purpose of the intellectual properties. That basically is making the human being to think that how these are the novel, how these are the non-obvious to the other ideas. So as Ray was mentioning in the beginning, that in intellectual property we have four buckets, and we explained those four buckets in our earlier slides. One is a patent, another one is a trademark, another one is a copyright, and then the fourth one is a trade secret. So let's start to discuss our first bucket, patent. Before we start our first bucket, do you have any questions for me?
Attendees, please put your questions into the Q&A. If you're not able to put them into the Q&A, please raise your hand and I'll allow you to speak.
Thank you, Chris. And Chris, since I'm presenting my screen, so I'm not going to be able to view my screen, like if anyone has a questions in the chat window. So please assist me to provide me that question, if you don't mind.
I sure will.
Thank you.
Don't
So
everybody put in a question at one time. No, I don't have any questions right now.
Thank you, Chris. So let's start to begin our first bucket. The first bucket is a patent. So when somebody says the patent, so to be honest with you, I learned about the patent when I was in a college. When I was in college, I was studying my chemical engineering, and I was doing the research report on a nanotechnology. And at the time, I came across with what is the word of the patent, because my professor said, before you start your research, just do the Google patent search and trying to find out if there is any references out there with respect to the nanotechnology. And I said, okay. And at the time, I was learned about the patent, and it was so much fascinated to me. So as you can see, I was so much interested in a patent. So you can see me right now, I'm serving with the USPTO, and it is my honor to work with the USPTO. So let's start with what is a patent. So patent for the invention is the grant of the property right to an inventor issued by the United States Patent and Trademark Office. The right conferred by the patent grant is the language of the statute of the grant itself, right to exclude other from making, using, offering for sale, or selling the inventions in the United States, or importing the inventions into the United States. What is granted is not the right to make, use, offer for sell or import, but the right to exclude other from making, using, offering for sale, selling, or importing the inventions. So this is the main purpose of the patents. Once you have an innovative idea, you want to protect your innovative idea. So if you protect your innovative idea by using one of the intellectual property right, so it can exclude the others from making, using, offering for sale, or selling or importing the innovation. Once a patent is issued, patentee must enforce the patent without the aid of the USPTO. And while we're discussing the examples of the mobile device, we discussed some of the patent types, but I want to just explore more and give you more information on that. What are the types of the patents? There are 3 types of the patents. Yes, there are 3 types of the patents. One is the utility patents, another one is the design patents, and the third one is a plant patents. So let's discuss what is the utility patents. So utility patents may be granted to anyone who invents or discovers any new useful process, machines, article of manufacture, or compositions of matter, or any new and useful improvement thereof. Generally, the terms of the new patent is up to the 20 years from the date on which the application for the patent is filed in the United States. So you have to understand it's not when a patent is granted, but the 20 years started when you file your applications in the United States. And then design patent may be granted to anyone who invents new, original, and ornamental design for an article of the manufacturer. The term of the new design patent is 15 years from the date of grant. So did you see the difference here? The utility patent grants as well as the design patent grants. So basically, utility patent has 20 years of the lifeline, and the design patent has 15 years of the lifeline. The third and the last one is a plant patents. So plant patents may be granted to anyone who invents or discover and reproduce any distinct and any new variety of the plants. The terms of the new patent is 20 years from the date of the filing application. So here the utility patent as well as the plant patent have a same life cycles, like up to 20 years from the filing date, while the design patent is 15 years from the grant date. So this is a very good example. Is about our former president Abraham Lincoln. And did you know that he is the first president that has the patent? So on May 2022, 1849, Abraham Lincoln received the patent number 6469 for a device of the lift boats over the Shoals, and the inventions which was never manufactured, but however his idea has been protected. However, it did make him the only US president to hold for the patent. So design patents. So this is the examples of the design patents. This is just basically it shows the external appearance of the device that we use in our day-to-day life. Here is the example of the game console. So design patent protects the ornamental appearance for an article. This can be the shape, configuration, or surface of the ornamental applied to an article or board. So here from this example, you can look at it, the shape of the game console, some specific features that you can visualize from the external surface of the game console. And this is our third plant patents. That plant patent is the distinct and new varieties of the plants, and such as cultivated sports, mutants, hybrids, and newly found seedings.
Dimple, before you move on from plant patents, how common
Yes,
are, Dorothy asks, how common are plant patents compared to the other 2 types of patents?
Can you repeat one more time?
How common are plant patents compared to the other 2 types of patents?
So plant patents is basically more about the process and about the more related to the biological side, and that's why it's called as a plant patent. But to be honest with you, I'm not a plant patent examiner, so I cannot give you that much more in a depth answer. But if Dorothy wants some more information, I can definitely get her contact number and I can reach out to her on a separately and give her more information, unless Ray has some feedback to add, some information to add on.
No numbers, honestly, but we do see a lot less plant patents just because of the industry itself. It's less demanding per se than compared to other patents like utilities. The utility patents are more common for
Mhm.
patents itself.
But as far as I know that for the plant patents, some certain categories of the biological stuff that's classifies under the plant patent. So plant patent has a different classification system, but however, examination process for the plant process as well as the utility process application is the same. There is nothing distinct or there is nothing specific examination process for the plant application. No, it's the same.
Perfect. Thank you, Dimple.
Mhm. Thank you, Chris, and thank you, Dorothy, for that excellent question. So before we move to the our part to the patents, if anyone has any questions, please feel free to use the chat box or raise your hand and share your questions with us. So in this slide, I'm just gonna give you some brief overview. How is the process works at the patent office? So basically, it start with innovative idea. So let's say you have an innovative idea and you want to prevent the idea, and the solution for the innovation is that you may want to patent your innovative thoughts or ideas, and that's an excellent way to prevent your ideas. But there are several steps that you need to take it before you go on an innovation in an intellectual property journey. So first, if you think that your idea is a novel, non-obvious, just for a safety side, just do some research. We have so many resources online that you can use for research with in line of your innovative ideas. So one is a Google patent. Google patent is a great resources to everyone. But however, if do you know that Dallas Patent Office, Texas Regional Office has in person the service desk that can help you with respect to the researching in with respect to your novel idea. Also, we have several resource informations that Texas Regional Office is available that can assist our entrepreneur or our inventors or first time filers with respect to that application. So we have the numerous online resources, and after my presentation, Ray will go over that resource information, give you more information that what kind of services are available. So I want to save that tender for Ray. He will definitely share with you that information. So let's say you did all your online searching and you think that no, your innovative idea is a novel, non-obvious, then you may think to prevent the innovative idea by patenting it. And how would you do that? What is the first step? So once you have a new idea, you can file your provisional application. This is optional step. But however, sometimes if you have an idea, but you think that your idea or your research is not completed yet, so you just file your innovative idea under the provisional application. It will allow our inventor 1 year to perfect that application. So in a provisional application, you don't need to you don't need to file a claim. You just need to have a specification. If you have a drawing, you can submit that, and you can submit your abstracts. So you can see it's not that big requirement to file the provisional application. But however, once you file the provisional application, you have 1 year to complete your application, and you can file your non-provisional application. Some inventor, they have a perfect application. They don't want to file the provisional application, so they can go for the non-provisional application, and they file the non-provisional application. Once they file the non-provisional application, it classify and it goes to the perfect art unit to the right examiners who can examine your applications, make sure there are not your application is a novel and non-obvious over the other references that examiners came across. If it's a novel, non-obvious, the inventor will grant it with a patent. So you can see if you file the provisional application, it will give you the benefit of the filing date. So your filing date will start from the 1 year when you file your provisional application to the until to the patent grants. So it will prevent the other to steal your idea. It will it will prevent the other to sell your ideas to other. So that's the reason why we always encourage our applicants to file the provisional applications in order to get the benefit of the filing date when they file for the non-provisional application. Non-provisional application is called as utility applications or the plant application. And the initial cost of the provisional application is lower than the non-provisional application, but you have to keep in mind that provisional application does not go for examination. It will just give you the benefit of the filing date. It will not go on examination. It won't get classified. Only the non-provisional application will be examined. So now we will start our second bucket, trademark.
I was able to answer that question with the patents. I did put it in the Q&A. We do have public information that we do every year. It's called the PAR that we publish it on our USPTO website. So I did look up the PAR report, and it does show about 0.2% patent percentage based on cost. So I did put that in the Q&A for you guys to reference.
Okay, thank you, Ray.
Mm-hmm.
So our next bucket is the trademark. So what is a trademark and how, because sometimes you heard the trademark, service mark. So you want to see what is the distinction between the trademark, what is the definition of the service mark. So trademark is a word, name, symbol, or design combination thereof that is used in a trade with the goods to indicate the source of the good and to distinguish them from the good of others. On the other hand, the service mark is the same as a trademark, except that is that identify and distinguish the source of the service rather than a product. Trademarks Trademark rights may be used to prevent others from using the confusingly similar mark, but not to prevent others from making the same good or from selling the same good or service under a clearly different mark. So you have to keep in mind those things. So let me give you the example of the McDonald's. So let's say you are driving by and you see the McDonald's signs, you see the McDonald's restaurants. So when we see the trademark golden arcs, we know the quality and consistency should be the same across the all franchise. So here at these restaurants of at the McDonald's name is the service mark because it's provide the restaurant service. The golden arcs are the trademark logo. McNugget is one of the menu item, is a trademark product name. So there can be the multiple level of the trademark and service marks within the business. So now when you driving on a highway and if you see any other restaurants, just keep in mind about the trademark and service mark. So here are some other examples of the trademarks. So as we mentioned, the trademark can be the word or and a design too, such as the Starbucks. Starbucks is in a word, that's a trademark. And the logo of the design of the Starbucks is also trademark. Nike, Target. So these are just only few examples, but in our day-to-day life, like we will see so many other products that associate with the trademark words or trademark design. But as we talk about all the time, the trademark is consisted of the words, logos, graphical design that apply to the goods or packaging. But there are some non-traditional trademark. So those are the associate with like a trade dress, such as the product design, packaging, or configuration. Then color, scent, sound, taste, touch, and moving images. when we say moving images, that combining of the color, sound, aspect of the product design. So those are the basically examples of the non-traditional trademark. So here are the few non-traditional marks that I'm sharing with you on this screen, and that's are the associate as a color non-traditional trademark. So first example, you can see the gift box that's very well known. It's called as a Tiffany Blue from the Tiffany and Company. The middle one, everyone can aware very easily. It's a UPS logo because of the brown and yellow combination. The third one, John Deere, is a green and yellow color scheme. Non-traditional marks is sent as a non-traditional mark. So first one is strawberry, cherry, and grape lubricants for engine to make your exhaust smells good. Did you ever know that Verizon has a flowery musk scent? I didn't know that. This is I was also amazed when I heard that Verizon store has this flowery musk scent. So I said like next time when I visit the Verizon store, I will definitely pay attention on that one. But if you guys are the Verizon customer and if you visit the Verizon store, just let me know if you can able to smell that flowery musk scent. The third one is a Play-Doh. The Play-Doh is a scent of the sweet, slightly musky vanilla fragrance with a slight overtone of cherry combined with the smell of salted wheat-based dough. Another sounds as a non-traditional marks like Pillsbury Doughboy, NBC, and then chime con like in a play game. This is the example of the non-traditional trademark is a trade dress. The first one is it's intended to protect the consumer from packaging or appearance of the product that are designed to imitate the other products, must be non-functional, and trade dress must be distinctive. That means that consumer perceives a particular trade dress as identify a source of the product. Over time and with advertising and exposure, consumers associate the design with the source of the product. So first example you see is a Dr. Martens boots because it's well, you can recognize that one very easily because of the some specific configurations. One is the yellow stitches in a welt area of the sole. Then second one is a two-tone grooved sole edge. Third one is a distinct DMS sole pattern. And the fourth one, the black fabric heel loop. The second example is a Hershey's Kisses because of the shape and the packaging appearance. The third one is the Apple product store. So it has a specific layout. And the fourth one is a Coca-Cola bottle shape. So third bucket of our intellectual property is a copyright. So what is copyright? So copyright is the form of a protection provided by the law of the United States to the authors of the original works of the authorship, including literacy, dramatic, musical, artistic, and certain other intellectual work. Copyright is a bundle of rights that gives the owner the right to make copies, prepare derivative works, or maybe modifying the works, distribute the copies, perform the work publicly, and display the work publicly. The requirement of modicum of creativity sets a low bar for the copyright ability. An example of something that does not qualify under the copyright is the white page sections of the font book that does not have the enough creativity to be copyrightable. So these are the examples of the copyright. As we know that copyright is a form of the protections that provides by the law of the United States to the authors of the original works of the authorships, including the literary, dramatic, musical, artistic, and certain other intellectual work. Here is the first example copyright. You can see songs can be copyrighted, books, and movies, sculptures, sounds. These are the examples. Some of the examples that listed here that can be protected by the copyrights, such as logos, product designs and packaging, advertising, promotional material, instructions manuals, educations materials, software source code, and website content. There is some crossover here between the type of IPs. So you can see here logos can be both copyrighted and serve as a trademark. Matter or process executed by the software code may be patent protected while the actual source code is a copyrighted. So you can see there are some few examples that can be protected by the multiple intellectual property. The last bucket of the intellectual property is a trade secret. This is our last bucket of the intellectual property. So what is a trade secret? So trade secrets consist of the information can include the formula, patent, compilation, program, device, method, technique, or process. To meet the most common definition of a trade secret, the information must be used in the business and give an opportunity to obtain the economic advantage over competitors who don't know or how to use it. You know, there is a differences between the patent and the trade secrets. So here is the some comparisons between the patent and trade secret. So utility patent lasts 20 years from the time of the filing. However, the trade secret lasts as long as it remains secret. In a patent, you must disclose how to use your invention within your application. And in trade secret, you must take the reasonable steps to keep your trade secret secure. So basically, it just basically saying that trade secrets, it is your responsibility to keep your secret secure. In a patent, there may be the legal remedies should someone makes, use, or sell your invention without your permissions. But however, in trade secret, it's all your responsibility to secure your trade secret because there may be just legal remedies should someone steal your trade secret. And someone can still try and improve upon what you have done and get a patent on that improvement. On a trade secret, someone can still try to reverse the engineer what you have done. So these are the differences between the patent and trade secrets. And these are the examples of the trade secret. So Krispy Kreme got it started in 1937 when the Werner Rudolph bought a secret yeast to raise the donut recipe from French chef from New Orleans. So basically the donut recipe is just basically the secret for everyone. The Coca-Cola's formula is also secret. Nobody knows how they make the Coca-Cola, but however, everyone enjoyed that Coca-Cola. The KFC's 11 herbs and spice is a trade secret. In fact, even the head chef at the KFC has claimed that he doesn't know what is in the 11th herbs and spice. And still that chef is making the KFC chickens. Google PageRank is a hybrid in that original formula for scoring link is a subject to the patent protection. However, Google combats manipulation of its PageRank algorithm by link farm and other tool is a closely held trade secret. So here are the few examples of the trade secret. This is just basically the table we call as that the cheat sheets. It's give you the all the information about the 4 buckets of the intellectual properties that we just discussed, what we can protect it, what are the requirements, what it protect against, and what is the endorse until, and what is the right of independent creators. So this is really very helpful when you are new to the intellectual property and you want to know more about the intellectual property. So this basically table will help you guide you to learn more about the intellectual property. Any question for me before I hand over to Ray?
Let's see. And remember, if you would like to ask a question, please raise your hand. Steffi is raising her hand.
Dimple, how much help can a client receive from the Texas Outreach Office? Like, do you guys do a patent search? Do you do a trademark search? What kind of help would we get, would contact you?
I can take that one, Dimple. We do have a public facility to help with the searching. For searching though, we would rely on our PTRCs, and they'll probably be easier to work with because they're more closely by. And I'll talk about the resource of what PTRCs shortly. But if you wanted to come into the office and use our public searching facility, there is that option, and then there is some limited assistance they can help you with the searching. But I would recommend more the librarians at USPTO trains through PTRCs, just because they're more local and they're more focused on the patent searching aspect.
Okay, thank you. Thank you.
If there's no other questions, I'll definitely take over and do the USPTO resources. So next slide, please, Dimple. So really the number one resource we do have is our website. So there's a vast amount of information in our website. When I was in SBA, I used to use the USPTO website quite a bit to reference certain topics and intellectual property as a whole. So and everything that we have, some of the questions that I've answered, I usually get from our USPTO, because we try to put all the information that we have that we can share to the public, we put it in our website. I would also recommend to subscribe to our newsletters. That's our number one way of communication to the outside public. So definitely subscribe to the national one and even to the regional office here in Texas, just for more intellectual property updates from the USPTO office. Next slide, please. So we do have a website dedicated just for startup resources. So there's resources from state, local IP sections that we have in here, directs you to your state, appropriately trademark information, scam prevention. There's a lot of scam out there. So definitely the ones we know and that we try to tackle, we put them out there to let public know, because consumers know, just so they can try to avoid these pro se applications that are out there and people pretty much representing themselves. We try to put resources out there, and then ongoing education that we do throughout the year. We do have a popular program, which is patent and trademarks boot camps, that pretty much walk you through the process of how to file for a patent or a trademark application. Those are very popular that we do throughout the year, and you can access them here as well. Next slide. We do have 1-800 numbers for trademark and patents. These 1-800 numbers will help you with any general questions or inquiries that you may have on the process. So they're very well known for USPTO. They're managed extremely well, and they can definitely answer any basic question that you may have on the process itself. They can't give legal advice, but they can definitely guide you to a place where you need to be so you can make informative decisions. And for the Trademark Assistance Centers, there's also an email that you can send them. We do have next slide, please. We do have another one for patents, which is the Inventors Assistance Centers, which their phone number's in here. And basically the same concept, 1-800 hotline that we have dedicated just for customers and inquiries that come in. So a lot of it will be basic questions of, what the process is, what can be patentable, but a lot of times, it may fall under the legal advice. So they'll just give you the definitions to help you do informative decisions. So next slide, please. Definitely those, take advantage of those, because they're available to everybody here in the United States. So we do have profiles you can create so you can check your trademark application, what we call a docket. And in there, it's a little bit easier to be able to file for an application and do responses. So that's something that we definitely recommend for individuals to do. They're filing applications, the trademark applications specifically. And then they have quick links to be able to access a change of address, responses, and just keep a track of all the trademark applications that they have. And the next slide, we do have an app as well, a little bit more accessible for trademark status in case it's people are used to apps now. So it's definitely something that we have out there for individuals to take advantage. Next slide. There we go. We do have an IP awareness assessment tool as well. This is used a lot by business advisors through SBDC networks in the private sector. And this helps you identify your path, your knowledge in IP and your path. What if you have a specific idea, you can put based on your answers, you'll be able to identify specific areas that of intellectual property that your path may hit. But it's something for you to make you aware of different areas that you're getting involved in intellectual property, so you can kind of do some more research on it. So this assessment tool, you can find it in our website as well. Next slide, please. So USPTO does recognize that the patent applications can be costly, so we do have pro bono assistance throughout the nation. So there's coverage in all 50 states. There are requirements for the pro bono program. USPTO does certify these pro bono organizations. So they are certified through USPTO. They just have to abide by the discipline office that we have. And also the participants have to abide by the requirements that are given. And these are general requirements. Some states may differ. I know some states have a 200% below federal poverty guideline, but for the most part, you're looking at about 300% of the requirement. You still do need to pay USPTO filing fees. Like I mentioned earlier, USPTO is a fee-based agency. Demonstrate a knowledge of the patent systems, and usually do this by taking a training course at USPTO website. And there's also your application has to get pre-screened to make sure there's more than an idea. So those are some of the basic qualifications you're looking for the pro bono program. It's a good overview of the coverage throughout the states. So like I said, every state does have coverage, and you can look these up in our website as well. Next slide, please. We do have another form of pro bono assistance, which are the trademark and patent clinics. It should pop up shortly, but pretty much what these are, that's the one for here in Texas, TALA. We go on to the next one. That's the pro bono program for Texas. I think for New Mexico, I think you guys fall under Colorado's pro bono program. And they cover the New Mexico side as well. The law school clinics, though, they're USPTO certified as well, and they're law schools that have IP in their curriculum, and their students gain experience by helping you with patent and trademark applications under supervision of a facility supervisor, which have the IP experience. So this is a good win-win for the students and for the small businesses because they both get a pro bono assistance and experience. New Mexico doesn't have any, but there are some in the surrounding states that they can cover. So I would definitely check the surrounding states for assistance. And these are some of the ones we have in Texas, of course. There are some that do cover outside the region, so I would definitely check within the trademark and patent clinics in the surrounding states. Next slide, please. These are the PTRCs that I was talking about earlier. We have patent and trademark resource centers, and these are trained librarians through USPTO that will help you with the patent searching and trademark searching. So we do recognize that usually the number one step after you have an idea is it already out there? Is there prior art to it? So these PTRCs are very beneficial for individuals to help you do the searching. You can always play for the private sector side of it and get legal and get an attorney to be able to do it for you. But that just adds a little bit more cost. So the PTRCs will be free of charge, and they're around the nation. Your point of contact for New Mexico is David Irvin. And he's a great PTRC librarian that can definitely take time and assist you with the searching. I'm going to the next slide, please. We do have a track 1 process to help prioritize your patent examination. There is an extra cost for it, but there is that option in case you wanted to expedite your patent examination. Next slide. It's like a fast pass at Disney World for patents. There's Air Forms, which is something that we definitely recommend. A lot of times when you're doing a patent application, it's something new and innovative. So it's hard to describe in actual words and paper a lot of times. So patent examination is a good way to talk to the patent examiner and relay what you're trying to do. These actually help increase patent examination process and definitely help convey your message at the end of the day. But it's something that you have as a patent applicant to be able to do. Next slide, please. We do have an ombudsman program as well, so that helps you in case there's any issues in the patent examination process. The ombudsman will serve as a third party and help you get your application back on track. Now, usually not something that we see, but just for your reference, in case you do need to access them, we do have an ombudsman program for patents. Next slide, please. The last slide, we do have what we call micro-entity status at USPTO. So this is for small businesses in the area. So you're looking at 75% off most patent fees, low cost submission to establish filing dates. The application filing fees do differ. I think that we can put the fee schedule, the updated fee schedule for you in the chat so you can access it. But USPTO definitely has micro-entity status, and it categorizes small businesses as fewer than 500 employees. Another requirement would have to be that the inventor hasn't been named on 4 or more previously filed patent applications. So that's a big thing. We definitely want to see new people into the system so they can be able to take advantage. We do notice that once they go through the learning curve, they do tend to use the system a lot more. And besides that, I think the last slide just has our information. We're always welcome for one-on-one consultations. You got to the last slide. And it's pretty much, we'll help you get to do informative decisions. We'll guide you. We will definitely, we can't give you legal advice, but we definitely give you the resources and connect you to individuals that you need to. And we try to educate you as best as possible to do the informative decisions to continue your intellectual property path. With that being said, that's it for me. In case you have any questions, I'm here for a couple more minutes, so let me know. I do see Dimple was chatting away with some information. It was great to see.
Well, thank you, Reynaldo and Dimple. That information on intellectual property and all the buckets was very interesting and very good. You can also contact the TCA if you need any help or have any questions on the intellectual property.
Thank you.
I do have one question on the pro bono and the law school clinics. Do they help write a patent?
They help you with the drafting application process,
Okay.
yes, for the legal fees. Yeah.
Okay.
So
and also you mentioned the PTRC, Patent and Trademark Resource Center, David Irvin down here at New Mexico State. And Dorothy, he has all the plant patents stored down here at State. So that's real interesting to find that out. So,
yeah.
So thank you.
It's a great point of contact for New Mexico.
Pardon?
He's a great point of contact there for New Mexico State.
Oh, yes, yes. He has, I send a lot of our clients there to help them do a patent search or a trademark search. So that's very good. So thank you for the Texas Regional Outreach USPTO. And they have been wonderful all year. They have provided other classes, IP strategy for us, train the trainer. That's been awesome. So thank you very much, Reynaldo, and your whole group.
Thank you.
Sometimes when you have intellectual property, it can be very expensive, creating your prototype, coming up with your proof of concept. So we have DeRego Catron from New Mexico, from NMFAS at the Arrowhead Center at New Mexico State, and they help New Mexico residents with their with seed funding or applications for seed funding. So with that, I'm going to introduce DeRego Catron from NMFAS.
Thank you. Okay, let me try and share my presentation.
And Dana, we have your presentation to be distributed. Is that okay?
Yeah.
Thank you.
Okay, so I'll just get right into it. Thank you so much. Again, my name is DeRego Catron. I'm the Deputy Director for Arrowhead Center. We're traditionally the IP and Tech Transfer Office for New Mexico State University, but we also have a number of other entrepreneurial and innovation-based programming. So NMFAS, which I'll talk to you about a little bit later in the presentation, is one of those programs, and it is focused on SBIR and STTR funding. Oh, let's see. So today, what I'd like to cover with you all is an overview of the SBIR and STTR programs, what the proposal process looks like, especially if you're a first-time applicant or you're looking at applying to SBIR or STTR for the first time. It's really good to see kind of a high-level overview of what you'd be getting yourself into. And then I'll talk briefly about our FAST program here at Arrowhead Center and how we can help you if that is something you do want to pursue. And then if you have any questions during the presentation, feel free to unmute yourself and just ask. It's kind of hard for me to monitor the chat while I'm presenting, but you can feel free to interrupt me. Okay, so going straight into what are the SBIR and STTR programs? So SBIR stands for Small Business Innovation Research, and STTR stands for Small Business Technology Transfer. We often refer to these two programs as sister programs. They're very, very similar, but they have some very distinct differences that we'll talk about here in a little bit. But basically, they were designed by the government to really inject seed money into small businesses to help move high technologies and innovations closer to commercialization. So trying to bridge that that gap between really between friends and family, money and dollars, and investment. So these programs were designed to fund very early stage technology development, and there's really no other funding mechanism available for early stage tech development. The goals of these programs, again, they are to meet the federal R&D needs by providing those really critical research dollars directly to the small business. The government wants to increase private sector commercialization of innovations, again, derived from federal R&D funding, stimulate technological innovation, foster and encourage participation in innovation and entrepreneurship by underserved businesses, and then for STTR to foster tech transfer between small businesses and research institutions. A big part of SBIR and STTR is eligibility, right? So very first thing to consider is figuring out if you are in fact eligible to apply to these funds. So you must be organized for profit and your place of business must be located in the United States. So that's number one. Number two is more than half of your business needs to be owned and controlled by one or more individuals who are citizens or permanent resident aliens of the US. This is really, really important. We often have clients who don't quite meet this criteria, and unfortunately they are not eligible for SBIR and STTR. So make sure that those 2 criteria are met. And then the last one, this doesn't apply. I don't think we've ever come across this with any of our clients, but you can't have more than 500 employees. And that's based off of the SBA definition of a small business. So again, actually all clients we work with through NMFAST are absolutely fine in that category. Another thing to consider about these programs, the focus is really on performing R&D. These funds are not designed for purchasing things like equipment or for commercializing a technology that has already been developed or one that has really low risk and only needs capital. So again, this is for high risk, very early stage technology development. Regardless of the agency that you apply to, and we'll get into all of the different agencies here in a little bit, there will always be a technical challenge focus with any SBIR or STTR project. So the agencies are looking for the business to solve a technical challenge with their innovation. For granting agencies, the small business will be the one to identify that technical challenge. For contracting agencies, and again, we'll talk about the differences between granting and contracting, but for contracting agencies, the agency will tell you what their technical challenge is, and then you'll need to address that with your technology. So kind of think of it this way. If you're the agency and you can say, if I can already go out and buy it, I'll do just that. Those funds are not designed for things that are already available in the market. It does form a backbone for growth for your company. So there's a lot of examples of very, very successful companies who were able to start and grow using SBIR and STTR funds. And then solving a technical challenge allows you to look at other issues for your product or business. So can your product or technology be made better by doing X? Can you cut costs by doing Y? So it brings up other questions and issues that will, again, help move your business forward. Okay, so why is the government interested in giving out free money? And we, again, also call this the government seed fund. So they want to build a stronger economy for America and understand that small businesses are a huge part in making that happen. So the more businesses that succeed, that equates to more tax revenue, more job growth, things like that. And actually small businesses account for over 44% of US economic activity. So it makes sense to fund small businesses. It also helps to build a stronger innovation pipeline. So small businesses produce 16 times more patents per employee than large businesses. And they also employ about 40% of America's scientists and engineers. So again, it makes sense to inject money into small businesses. Looking at the 2 sister programs, so SBIR, they both support R&D and financing of innovative technologies. Again, some differences. So SBIR is a bigger program. It's about a $3.8 billion annual set aside. And the way they calculate that is it's 3.2% of the extramural research budget for all agencies with a budget greater than 100 million per year. What that means is if an agency goes below that $100 million mark, they don't have to participate in SBIR anymore. And if an agency that, right now is less than 100 million, but goes over that 100 million mark, maybe next year, they would be mandated to participate in SBIR. So that's always in flux. We haven't seen any change in the agencies that participate in, at least in the time that I've been doing SBIR. I don't think there's going to be any changes here in the near future. STTR, again, the sister program, you have to partner with a research institution on that proposal. It's a little bit smaller, so it's only 0.45% of the extramural research budget for agencies with a budget greater than 1 billion. So there's only 5 agencies that are able to participate in this. And that equates to about $518 million set aside per year. One thing to remember also about both of these programs, you as a small business will always be the applicant and the awardee. So even if you partner with, say, a university on an STTR, the university would not be the one receiving the funds. You as the business would be the one receiving the funds. So some differences between the two programs. Partnering requirement, you can partner with SBIR. That's absolutely fine if you want to do that. With STTR, you have to partner. So that's kind of the big difference, is it's a requirement for STTR. And a research institution, I can pull up the exact definition, but it's basically any large institution. So in New Mexico, for example, the three big research universities, so NMSU, New Mexico Tech, and UNM are all research institutions along with the national labs. So you could partner with any of us on an STTR or an SBIR too. For the PI, with SBIR, the primary employment has to be with the small business. So over 50% has to be with the small business. With STTR, the PI can be employed by either the research institution or the small business. So there's a little bit more flexibility there. For work requirements, again, SBIR, you can outsource up to 33% in a phase 1, 50% in phase 2. STTR, it's increased a little bit. So 40% has to go to the small business and 30% to the research institution. For IP, this is a question we get asked a lot. So with SBIR, a formal IP requirement is not required unless you're working with a research institution or something that would require an IP requirement. With STTR, you do have to have a formal IP agreement in place that is signed prior to the award. With that said, if you are interested in STTR, we always encourage clients to start working as soon as possible, because those IP agreements can take a while to negotiate between the research institution and your small business. So the sooner you can get started on that, the better. You don't have to have it signed to submit the proposal, but it does need to be signed prior to the award. So there is some wiggle room there with the timing. For participating agencies, there are 11 agencies, 12 departments that participate in SBIR, only 5 for STTR. And then I already talked about the program size. SBIR is quite a bit bigger than STTR, but again, it's because more agencies participate in that program. So this is just a chart of all of the different agencies. Again, we say there's 11 agencies, 12 departments, because there are 2 under the Department of Commerce. So NIST and NOAA are situated under DOC. All of these participate in SBIR. The ones that are in gray are your STTR agencies. Now, this is where it gets really confusing. And so that's why New Mexico FAST is here to help. So we're kind of talking about these as, SBIR and STTR is kind of 2 programs, right? But then you have to break it out into the 12 different agencies or departments. And so that's 12 additional programs. And when you break it out into STTR, that's an additional 5. And then in the next slide, I'm going to show you how within each of these agencies, there are different components or departments, whatever that agency calls them, that make this even more confusing. And the reason being, there's no standardized proposal process for SBIR and STTR. It is completely up to the agency and the department on how they want to run their SBIR program. And so they all run them differently. So they all have different cycles, they have different requirements, and we'll talk about the differences here in a little bit, but it gets really confusing when you start kind of diving into all of the different agencies, because you have to treat them all as separate programs. So this is a chart of all 12, and this is going to kind of illustrate why it's confusing. So under DoD, there are 14 different components. All of these have different requirements for their SBIR and STTR programs. So it can get really confusing really fast. DHS has 7. HHS has 24 NIH institutes and 3 other HHS agencies. HHS is a little bit confusing because we often talk about NIH. NIH is obviously the biggest institute under HHS, but the SBIR program is actually situated under the Department of Health and Human Services, and then NIH is a component under HHS. Under DOC, there are 2, NIST and NOAA, and then under DOE, there are 12 different DOE components. So again, it's can get really confusing really quick because there are so many different requirements and processes for all of these different agencies and components. Oh, and then 8 DOT components. I'm not going to read through the slide. This is more just so you can have this as information when the slides get sent out. But this is generally what these agencies tend to fund. So you can refer to this later. Some of them are really obvious, like NASA obviously is going to support space-based innovations. HHS is going to be more health focused. But one of the things I do want to mention is for things like DoD. When you think of DoD, most people automatically think of warfighter, right? So weapon development, military, things like that. But DoD also funds health. They fund egg-based things. They fund a lot of different things because if you consider, for example, an aircraft carrier, that's essentially a mini city on the water. So they are going to have to fund and be responsible for all kinds of things outside of weapon development. So think broadly when you think of DoD, and again, one of the things we walk you through NMFAST is how to kind of navigate all of these different agencies and where the best fit is for what you're doing. Okay, so grants versus contracts. This is also a point of confusion for a lot of people, and so I wanted to bring this up because under the SBIR and STTR program, there are agencies that participate in either or both. So it's important to know the differences. With granting agencies, you're going to have less specific topics. They're a lot more flexible because they're designed to provide funds to support a public purpose. The PI has much more freedom in defining the scope of work. There's more flexibility in funds. It requires a best effort in research, things like that. So to summarize, grants are a lot more flexible than contracts. Contracts are very, very highly focused. So the agency is going to tell you exactly what they want to see. And if your technology doesn't fit within that, it won't get funded. A contract is a binding agreement between a buyer and a seller for goods and services. So there's a lot more or a lot less, I guess, flexibility there with a contract. The scope of work, not as flexible. Payments are determined based on deliverables and milestones, and there's a lot more fiscal requirements with contracting agencies. You will be required to deliver on whatever you promised, determined by whatever contract type you have with that agency. Questions and answers about solicitations have to be made public, and then the government will define the scope of work for you. So again, less flexible than grants. And then this is just who does contracts, who does grants, and then HHS is the only one that does both. So that chart's just there for reference. Now, so big question, how much money can you get from these programs? So again, I'm not going to go through this chart. It's more of a reference point for later, but you can see all of the different agencies, the phase 1 amounts, the phase 2 amounts, the duration of time. So phase 1 generally lasts anywhere from 3 months to about 6 months. NSF is a little different. It can go up to 12 months, but that's rare. Same with DOE. And then phase 2 is almost always about 2 years or 24 months. And then total program funding, just so you can kind of see the scope of how big those agencies are, obviously varies, but we've got that in the last column over there. So I kind of talked about phases in the last slide. We call the SBIR and STTR programs a gated program. So basically you have to go from one stage or one phase to the next. You can't go directly into a phase 2, or it's very, very rare to go directly into a phase 2. It is possible through agencies like NIH, they do have a direct to phase 2, but again, it's rare and those are very highly competitive. So in 99.9% of the cases, you have to get a phase 1 and then you can go to a phase 2. We also added phase 0. So phase 0 is essentially your proposal phase. That's when you're developing the proposal. And this is where you can get assistance from us. And there is microgrant funding through our program to help you develop that proposal. Phase 1 is going to be your concept development. So again, awards are usually about 100 to 250K over 6 to 12 months. The success rate is about 15%. So it's a very competitive program. Going into phase 2, this is where you're developing your prototype. So there's more money available over a longer duration and the success rate increases to about 45%. One thing to note too about phases. So say you get a phase 1 with NSF, you can get a phase 2 with any other agency. So as long as you have a phase 1 with any agency, you can go after phase 2 with any other agency. So it's not stipulated by agencies on how you can move from the phase 1 to the phase 2. Some agencies are now offering a second phase 2, which is kind of the demonstration phase. Again, this is not as popular. There aren't as many opportunities available, but there are some. And then your phase 3 is your commercial sales. So there's no direct SBIR or STTR funding for phase 3. But if your end user or customer is, for example, the Department of Defense, you could get Department of Defense dollars for your phase 3 through another mechanism. So it wouldn't be through SBIR, but you could get DoD funding again through another mechanism. So the backbone of these programs there's 2. So innovation and commercialization. Innovation does not necessarily mean high tech. So I talked about technology a lot. I would say 98% of funded projects are very tech focused, but there are other processes, lower tech processes and products that are highly innovative. So a really good example we like to give is a company was provided a NIH SBIR for comic books. So basically they had developed a very innovative process for using comic books for PTSD patients. And that was funded through, I believe it was NIH. Not what you would consider high tech, but it was highly innovative. Commercialization. The agencies are really looking for you to commercialize your product, and whether they're the end user or the general public is the end user, commercialization is the goal. So you have to, and we've seen this more and more over the last couple of years compared to when I first started with SBIR and when we started our program. Commercialization is built now into the phase 1, whereas before it wasn't really required until the phase 2. Now you have to be able to talk about it in your phase 1. So it's really important to start thinking about what is your market, what is your path to market, things like that. I'm not going to go through this too much for the sake of time, but again, just some questions to kind of ask yourself and to weave into a proposal about commercial viability. So these are kind of some things that we find are good to integrate into a SBIR or STTR proposal. Government contracting. So I wanted to talk really quick about opportunities for underserved businesses. There aren't any specific incentives under these programs for being an underserved business, but there are other contract opportunities to look at. So things like a certain percentage of contracts have to go to historically underserved businesses, and there are set asides for small businesses, 8A, women-owned, etc. You can certify if you haven't done so already through certify.sba.gov. You'll need some documentation, obviously, to get through that process. And these set-asides can be a really great vehicle for helping to grow your business and reducing the amount of competition on contracting opportunities. So if you'd like more information on that, beta.sam.gov is a great one-stop shop for more information. Oops. Okay, and then lastly for this section, why pursue this funding? Again, it's the government seed fund. So they are investing in an idea essentially, and they're not going to take any part of your company. You don't have to pay the money back. So we like to call it non-dilutive funding or equity-free funding. So it's essentially risk-free dollars for you to develop a high-risk idea or innovation that you probably couldn't get funded otherwise. It's very similar to the process of seeking third-party investment. So more agencies now are requiring some kind of a pitch. You have to know your product, the market, how it will be sold, things like that. We're here to help you there, the SBDCs. There's a lot of organizations here in New Mexico who are available to help with that part. And then probably the best part about SBIR, besides not having to pay the money back, is it puts you in a priority position for sole source sales to the government. So if you are looking to contract with DoD or NASA, this is a great vehicle for getting your foot in the door for those sole source sales. So proposal process, what does it look like? First, you need to determine eligibility. So make sure you qualify as a small business concern. So do you have less than 500 employees? Are you for profit? Are you primarily in the US? Is your work going to be done in the US? And is your PI primarily employed by the small business? If you can check all 5 of those off, you're in a great position to start the proposal process. Second thing, and maybe this should actually be reversed, and this should probably be the first thing, is do you have an innovative idea? So do you have an idea or technology that can respond to a specific need that the agency has or fit within the mission of the agency? After that, complete registration. So things like your DUNS, SAM, SBA company registration, and then agency specific registrations. We are here to help with that along with other organizations. I know PTAC is an excellent resource for getting these set up. I believe the SBDCs also provide some support for helping with business registrations. So reach out to any of us if you need help with those. Next is really determining topic fit and talking to the agency. So review that solicitation for agency priority problems that need to be addressed, and make sure that your innovation either solves those problems or fits within the parameters of what they're looking to fund. They are always interested in solutions, even if it's not the approach that they want. So sometimes there are opportunities to pitch an idea to, say, the DoD, for example. They're a great agency to use as an example. They are a contracting agency. And so when they put their topics out, they are very specific about what they are looking for with each of those topics. They're very specific. But they are also open to saying, or to talking with you. And if you have something that's incredibly innovative and of use to one of the components, they are able to create topic areas around a specific technology or innovation. So we have seen that happen where a company has a technology, and then it takes a while, but maybe a year later, a topic is released for that specific innovation or technology. For the proposal package, this can differ quite a bit depending on the agency and the component. But generally, you can expect to complete some kind of technical proposal or narrative. You'll need resumes or something on your team. Again, these can look different depending on the agencies. Something on facilities. You will always submit a budget. And then again, additional documents depending on the agency. I would say HHS has the most forms. They have you fill out a ton of different forms, whereas Air Force has you fill out a pitch deck. So I mean, it varies quite a bit depending on the agency. And then last but not least, and this is probably the most important part, secure a third-party reviewer to look through your proposal. This is so, so critical. We even do this internally when we're doing proposals because you miss things when you're writing it yourself. And so through FAST, we've got money to hire an outside reviewer. And then we also do reviews in-house for all the agencies and both SBIR and STTR. Then you submit the proposal. Don't wait to the last minute. We always recommend submitting at least one day before. You would not believe how many times the platform crashes, and the agencies are not lenient even if it crashes on their end. So we always say at least a day before so you can work out all of those technical issues prior to it being due. And then you wait. So award notification, depending on the agency, again, can take anywhere from 3 to 6 months. Sometimes sooner, sometimes longer. So again, it just depends. Okay. And then this is an older chart. We actually need to update this because some of the agencies have changed their process a bit, but this is kind of a high level overview of what you might expect if you're putting together a proposal package. And we generally say if you're new to SBIR and STTR, it's your first time putting one of these together, it'll take at least 100 hours from start to finish. So it's quite a commitment on your end, but it does pay out quite a bit if you're able to get an award. So this just shows kind of our process, what we do at NMFast versus what you as the client or the small business would need to do. Obviously, if you're doing this all by yourself, you would take us out. But again, there's a lot of different steps along the way. So we'll kind of talk about what our resources are that you can take advantage of to make this a little less burdensome. So NMFast at Arrowhead. I'm not going to go through this entire slide. You can review it later, but basically back in 2015, that's when we started our program. We noticed that a lot of our tech clients wanted to pursue SBIR and STTR, but there wasn't any dedicated assistance, like really in-depth dedicated free assistance in New Mexico. So PTACs and SBDCs do provide assistance, but they are strapped for resources as well. And these programs they change so quickly and so fast. And there's so much going on with all 12 agencies and all those different components that it's hard to keep up. And so we applied for the SBA's FAST program, which is money dedicated for providing SBIR and STTR assistance, and that's it. And so through our NMFast program, that is all we do. We live and breathe SBIR and STTR. And we make it our job to know about every single update for every single agency so that you don't have to worry about that. So this is just a little bit of background on our growth. Well, if this is going to, okay, sorry. So in terms of assistance, we offer a lot of different forms of assistance. I don't know why this is showing up in 2 different fonts, but anyway, if it has to do with SBIR and STTR, we will help you with it. So everything from topic identification, registrations, putting the proposal together, submitting the proposal, reviewing the proposal, all of those things we provide support for. We tailor our services for every client. So clients come in at different stages. We have many who come in have never even looked at SBIR before. And then we've got some who have applied several times and maybe they've won, maybe they haven't won. I mean, our clients are kind of all over the place in terms of their experience with SBIR. We do have microgrants available up to $2,000. Again, that's for proposal development and or conference travel, which we really encourage. We have a lot of free workshops and engagement activities held throughout the year. Most of these have been webinars since COVID, but we're trying to get back to in-person. If you go to our website, we have a ton of tools and resources. So we've developed resources for every single agency, proposal templates, compliance matrices, checklists, quick start guides, all kinds of things to help you with that proposal. We do send out a monthly newsletter that has all of the upcoming solicitations. It has upcoming SBIR and STTR webinars and events, but it's completely dedicated to only SBIR, STTR. So again, if it's something you're interested in pursuing, I would encourage you to register for that newsletter, and you'll get all of the information every month. We've also created a pretty robust YouTube channel. So we've got hundreds of videos on there that have to do with SBIR, STTR. We've got accelerators, which I'll talk to you about in a little bit. We do an annual SBIR STTR Innovation Summit every December. And what's really unique about that one, and it should be in person, hopefully this year. The last 2 years were virtual, but we want to get it back in person because we fly in program managers from multiple SBIR and STTR agencies to this event, and then they are available to meet with you one-on-one. So you get to actually sit down with program managers from multiple agencies to talk to them directly about what you're developing and your technology. One of our newer initiatives is Canvas, which is a kind of a learning platform. We're integrating all of our curriculum onto that platform so that it's self-guided. So if you don't want to, if you're just exploring at this point, you can go through that self-guided course to get all the information you need. So I kind of talked about this. I won't go through this in depth, but our living library and website, again, tons and tons of proposal development documents available for you to download. Our YouTube channel, this actually needs to be updated, but again, we have about 150 videos now on there. And one of the things we did do is create playlists for each agency, so that say you're only interested in NSF, you can go to the NSF playlist, and all of the NSF related videos will be right there for you. Our Arrowhead Center SBIR Accelerator. So this is one of our more recent initiatives that we're really excited about. But basically we have 2 tracks of these. So one is an SBIR 101 track, and then the other is an agency focused track. So we will be running an SBIR 101 track this summer, starting in July. So applications for that should be opening soon, actually. And that's usually a five-week accelerator, where the goal is just to learn a lot more about the programs. We really dive into all of the different agencies and what they're looking for, the proposal process. And then by the end, we want you to reach a go or no go decision regarding if you're going to apply or not. So again, that's coming up this summer. And then our agency focused accelerators are much more intense. So these are 12-week accelerators, and we say you can, it's from registration to submission. So you can come in, not be registered for anything, and by the end of that 12 weeks, you are submitting a full proposal package. I will say they are incredibly intense. You're developing a full proposal package in those 12 weeks, but we're hand-holding the entire way. So it's a lot more structured than trying to go about the process by yourself. And then you have a cohort of other businesses who are applying to that same agency, so you can bounce ideas off of each other. And they've been really successful in that respect. So I think we do have a DOE focused ACSA cohort coming up very soon. So if you are interested in DOE, I would encourage you to apply to this. All of our programs are free, by the way. So all of our accelerators are free. Our assistance is free. Again, that's what we get that grant from the SBA for, is so that we're able to provide this to everybody for free. So DOE, it's going to be a 12-week cohort this summer. And again, it'll get you from registration to submission. So in summary, what do? We assist you with anything SBIR or STTR related. So we can help you identify the appropriate agencies, the topic areas within those agencies, things like that. We will provide you with information on everything SBIR. We will guide you through that entire process. So we'll review things along the way. We'll help, again, just guide you through and navigate you through the process, because it's very, very confusing. These are federal grant and contract opportunities. So even just getting through those solicitations can be really intimidating and hard if it's the first time you're doing it. So we're there to support you for that. We've got lots of SBIR and STTR resources for you to access. Again, just go to our webpage. They are available now. And then we do things like review microgrants, things like that. So I think that is it. If you have questions, my email is right there. This is our the link to our website. If you're interested in learning more or applying to the program, there's a pretty quick intake application, and then we'll do an interview with you and get you onboarded. So with that, are there any questions? Or Steffi, I don't know if you wanted to save questions for later.
Dana, there's actually one question. What are the PI requirements, and where can Nate find them?
Sure. So that depends on the agency. But if you email me, I can provide more information on the specific PI requirements. The PI generally, so again, they have to be primarily employed with the business. This gets a little sticky when we have faculty who are interested in being a PI on an SBIR. NSF has a little bit of leniency towards that. The other agencies don't, unless it's an STTR. So that's usually something, if you're wanting to know more, I would recommend reaching out, and we can talk about the specifics of whatever agency and situation you have.
And I did put the presentation in the chat, so it's available to download in the chat.
Okay, perfect.
Dana, thank you. That was very good.
Yes.
What percentage do you have receiving SBIRs, STTRs?
Sure. So generally across the nation, win rate's about 15% for SBIR. Our NMFast win rate for SBIR is between 30 to 35%. So it's a little bit higher. If it's your first time applying, it's an almost guarantee that you won't get the award. So we always try to preface it with that, but it usually takes going through that entire proposal process to really kind of get the hang of it. And then we usually see the awards coming in on like the second or third try. So it is a bit of work and time to get it and to start winning those. But once you start winning awards, the companies that have won an award, they continue to win awards after that. So that's roughly about the percentage. And then those that go through our accelerator, it's higher because we're really working with them the entire way. So
The whole way.
Mm-hmm.
Right. And does everybody that, not everybody that applies, but do most get in to your program?
Oh yeah. So we don't through FAST, we can only support New Mexico businesses, but we've expanded our SBIR program now so that we do serve other states through other mechanisms. So some of our accelerators are open to other states. And so that's something I would talk to us about, but we never really deny anybody. During that intake meeting, if there is a technology we know that's absolutely not fundable because maybe it's already in the market or they're just not eligible for SBIR, STTR, that's the only time we would say maybe consider something else. But oftentimes what we can do is say, well, this particular technology or aspect wouldn't be fundable, but if you do something else, we can make that work under the program. So we'll work with you on, making you eligible for them. Yeah.
Okay. Well, thank you for presenting
Sure.
for our World IP Day. That's so exciting. And are there any other questions out there? We have some thank yous from Juliana Barbie. Thank you so much.
Okay. Well, thank you. And feel free to email me with any additional questions. We're happy to help.
Okay. So I think that concludes our World IP celebration today. And we want to thank all our panelists for presenting on intellectual property and SBIRs and STTRs. These are always very hard subjects. So if there's no other questions or anybody else want to make a comment, we'll leave it open just a little bit.
You want me to open it up to raise hands to speak?
Sure.
Sure. So if you'd like to speak, would you raise your hand for me and allow you to speak?
Well, I don't see anybody. Do you, Chris? Do you have any final thoughts, Christopher?
No, thank you for spending time with us today, and thank you for our panelists. I'll stay on with you, Steffi, so whenever you're ready, I'll be here.
Okay, well, once again, thank you for all my panelists for showing up. And if you have any questions, contact me, TCA, or any of your panelists that presented today. And thank you all so much, and have a great World IP Day. Thank you, Dimple. Thank you, Ray.
Thank you, Steffi. Thank you, Chris.
Thank you.
Have a wonderful day.
You too. Yeah, I have glasses and I wear them on my head instead of my face. There we go.
We still have some attendees here.
Let me graciously remove them. Okie dokie, I think all our attendees are gone. It says there's 3 panelists. Dimple's on with us.